Relocation. I know you all love these relocation cases. Oh my gosh, I'm not just over halfway through. So this is a case, Barendreght and Grebliunas. Thank you. So I'm using mother and father. There are two children, both under the age of 6, I think 3 and 5. Trial judge allowed the mother to move to the B.C.A. Valley to Telkwa, yay, B.C.A. Valley, from the Okanagan, but they're 1,000 kilometers apart. Two primary considerations were the financial situation of both parties and also their relationship with each other. Not so good on both fronts. They'd owned a home, they had significant mortgages, the house needed a lot of renovations, and they basically struggled to make ends meet. The father worked as a carpenter and the mother had various janitorial jobs. So the father appeals the decision, and he also wanted to, in his appeal, bring in new evidence about his financial circumstances, which he said, hey, it's gotten better. And what he says there, because the issue was that he couldn't afford to keep the family home. And that was one of the reasons why the judge says, yep, you're not going to have a home. Mom gets to go up to Telkwa, where she has some family. In the meantime, what happened was the dad's parents moved wherever they were, to Kelowna. And they also helped him by buying out half of the interest in the home so that they were able to pay out the mom for her interest in the home. Plus the dad was able to refinance the mortgage. So his mortgage payments went down. And then his parents were able to increase their line of credit so they could do the rentals of the house. So these are the new evidence that the father wanted to bring to the court, saying, look, stable financially, all good. The court said, yep, we can rely on this new evidence. And they also allowed the appeal. And why? Because the court held that the new evidence displaces the trial judge's concerns about the parties' financial positions and the father's ability to remain in the family home in Kelowna. And then aside from those concerns, the Court of Appeal said the remaining circumstances indicated that the best interests of the children were served by the children returning to the Okanagan under a shared parenting regime. They found the number of factors that favor the Okanagan, and I grew up in Kelowna, so I know a few of these factors, but they all stem around cherries. That's the reason to be in Kelowna. Both parents, I'm my parents, sorry. Hi, Mom, Dad. Both parents are good parents. The father has a strong bond with the children and has taken extraordinary steps to manage his schedule so he could be engaged with the children. Oh my God, this is one of those, a dad gets credit for like adjusting his schedule so he can spend time with his kids. And you know how many moms never get any credit for that. And they do it all the time. Anyway, they work miracles beyond extraordinary steps. Boo. The children had always lived in the Okanagan, fair point, and the father's parents had moved to Kelowna. And the mother didn't move to Telkwa to advance her career, to better her educational opportunities, or because she had a new partner there. She did have some family there, but she just wanted to get away from the situation with the father, really. There was no suggestion that the B.C.A. Valley had more benefits for the kids, or different benefits than were available to them in Kelowna. And the Court of Appeal noted that the trial judge had allowed the move partly because he was concerned of the father's past and future treatment of the mother, and found that, yes, the father was an overbearing personality and the mother had been subjected to emotional abuse. The court noted that the mother didn't actually argue that his hostility was one of the reasons to support her being able to move to Telkwa. And in fact, the mother had said things had gotten better after separation. The court said it's significant that the conclusions arrived by the trial judge that the mother's need for some emotional support and concern over the father's behavior have generally not on their own supported a relocation in the case law. So this is a big one. The need for a parent to be around other people like their own family for emotional support, not enough to tip the scales of relocation. And also the other parent sort of not nice behavior, abusive behavior, again, not necessarily enough to tip it over. You got to really look at all the other factors. So the Court of Appeal here says there's virtually no decision of this court where a need on the part of the moving parent for emotional support, even with some friction between the parties, has justified a relocation. They cite a couple just to sort of say, these, they kind of talk about it, but really pretty much no decisions. So the emotional support need is not a ground to justify, is not part of the, not a need, it won't tip you over in terms of a relocation. Permitting the relocation was inconsistent with the object of maximizing contact between the children and both their parents. Relocation always does that. It disrupts that principle of maximizing contact. That's why relocations are difficult. Anyway, but here they were worried that the relocation is likely to permanently and profoundly alter the relationship of the children and their father. There is no comment about the relationship between the children and the mother, because what if the mother stays in Telkwa? The court can't order her to move down to the Okanagan. Why is it the relationship with the father and the children given priority here over the mother and children? I'm not saying it's a wrong or right decision. I'm just noting that they seem to focus a lot on patting the father on the back. Anyway, this case is actually going out to the Supreme Court of Canada. So it's gotten leave to appeal. And so at some point, we will have a decision of the Supreme Court of Canada on relocation out of our province. How exciting. I'm just going to do a quick one on relocation under the new Divorce Act. Now, I know you've all read it and you all have memorized it. And you know that for the first time that there are actually provisions about relocation in the Divorce Act because there weren't before. And they more or less are consistent with what's in the Family Law Act. This is a case where the mom wanted to move with 3 teenage children to Hamilton, the eldest child starting school at McMaster, and the father was opposed to the move. The father was a bad dude, and so mom and children left the family home. There was a Hear the Child report, and the children reported they were scared of their father and noted the problems with his drinking, and they wanted to live with their mom. Now, the child going to McMaster was under the age of 19, but really there wasn't going to be an order in relation to her because of her age and being out of high school. Mr. Justice Colville in this case noted the father was taking positive steps to improve his situation, such as seeking treatment in relation to his mental health and his alcohol misuse. And he looked at the test of relocation under Section 16 of the Divorce Act, and considering the best interest of the children, he granted the relocation on an interim basis. The father had then conceded that for at least for now, on an interim basis, the children should reside with the mom. The court noted that the case law recognized that relocation is one of the most impactful decisions the court is asked to make, potentially having a long-term impact on children's relationships with the non-relocating parent. And this is, of course, very true when the proposed relocation is far away. And so the cases essentially recommend caution regarding relocation, particularly when it's at the early stages of proceedings and when it would be significantly different from the status quo that the children are used to. Of course, that doesn't mean that the court can't make decisions, but sometimes they'll want to not make the decisions in terms of relocation until there's, for example, a Section 211 report, or there's an actual trial where the evidence can be put forth orally and cross-examined. So anyway, despite all those warnings I just gave you, the judge says, hey, in this case, it's appropriate to allow the relocation to happen. And the judge considered the evidence in light of the new statutory considerations in the Divorce Act, the best interest of the child, the good faith provisions, and those considerations strongly suggest that the children's best interests would be served by moving to Hamilton with their mother right now.